Welcome to our second panel discussion on procedural obligations to investigate, prosecute, and punish femicide and gender-based violence under Articles 2, 3, 8, and 14 of the European Convention on Human Rights. In this focused dialogue, we will delve into the critical procedural obligations outlined in the ECHR that require diligent investigation, prosecution, and punishment of femicide and gender-based violence cases. Our esteemed panel of experts will share their valuable insights, shedding light on the challenges faced and the best practices that can be employed to ensure effective implementation of these obligations. The moderator will be the judge on the Constitutional Court of Bosnia and Herzegovina and former judge on the European Court of Human Rights from Albania, Ledi Bianku. And then his panelists, Erik Wennerström, judge on the European Court of Human Rights from Sweden, Saadet Yüksel, judge on the European Court of Human Rights from Turkey, and Kateřina Šimáčková, judge on the European Court of Human Rights from the Czech Republic. The floor is yours.
Thank you very much for this introduction. Let me start this second panel of our second gender forum today with the latest piece of information, if I may. Beginning of May, exchanging with the organizers of the forum, we are informing each other that the European Parliament had just voted within huge, almost unanimous decision, the approval to the Council of the European Union to accede to the Istanbul Convention. This was 5th of May. Meeting some EU MPs and lawyers of the European Parliament in Strasbourg, they said, well, now it would take years for the ratification, because now the ratification passes on to the Council of the European Union, because the Istanbul Convention was signed by the European Commission in 2017. Yesterday, the Council of the European Union, and I have to say under the Swedish presidency, voted for the accession of the European Union to the Istanbul Convention, which is a major legal development in the field of the topic we are speaking today. I'll revert to this issue later on during the questions, but I just wanted to share this information with you all because it is important. Now, moving on to the presentations and debates within this panel, and I'll start with Judge Yüksel. So prior to the break, we heard about the operational obligations under the European Convention of Human Rights to actually step in and take action to prevent harm where there is a threat that will be committed. Judge Yüksel, could you please kick off your second panel discussion, our second panel discussion, with an overview of what exactly these procedural obligations are and how they can and should apply in the specific context of domestic and gender-based violence?
Questions a bit expensive, so answer will be expensive. If you allow me, I'll use the... So pleasure to be here today at the Judicial Forum for Gender Equality in Western Balkans. I participated in last year's forum. It was an enriching experience, so I'm delighted to return this year. I would like to thank the AIRE Centre, Bilyan and her team, all the contributors, organizers, and special thanks to our dear friend, dear colleague, Judge Ivana Jelic, for all her efforts and for acting as a bridge between the court and the region. So at this session, if I'm not mistaken, we are going to discuss the procedural obligations to investigate, prosecute, and punish femicide and gender-based violence under Article 2, 3, 8, and 14 of the Convention. In other words, we are going to focus on the obligations of the states to have an institutional framework that takes gender-based violence seriously. Violence against women is perpetrated by private individuals, eradicating gender-based violence is not going to be possible unless state institutions acknowledge its fundamentality. And I think this was also mentioned by the Commissioner this morning. As many times noted by Council of Europe, widespread impunity and inadequate state responses to such violence leave many of the female victims of violence unprotected and without recourse to justice. So in this short time that I have today, I'll try to do two things. The first, to just give a brief overview of some of the procedural obligations that fall on the states, and the second, I'll try to discuss the interaction of these obligations and Article 14, the prohibition on discrimination. The first thing to note about the procedural obligations relating to domestic violence is that the obligations are comprehensive in the sense that they arise at every stage of analyzing the state's response to domestic violence and femicide. I will mention three of them, but even before we get to an individual case of domestic violence, there is an obligation for the state to establish an adequate legal framework affording protection against ill treatment by private individuals. This was recognized in landmark case against my own country, Opus versus Turkey, but I'll get to it when I discuss Article 14. In more recent cases, Volodina versus Russia, already mentioned by the colleagues, clarified that to comply with the obligation to have a legislative scheme, the authorities must adopt measures in the sphere of criminal law that appreciate the serious nature of domestic violence as a form of violence against women. This obligation can be fulfilled in many ways. I mean, some member states provide specific criminal sanctions for violence against family members, while others may provide domestic violence is an aggravating factor in crimes of violence. Then once an allegation of gender-based violence is made, the authorities have an obligation to effectively investigate the allegation. As many times noted in our court and also in some Turkish cases, there is no single factor that will determine if an investigation was indeed effective. Rather, it requires a holistic examination of range of factors, including but not limited to rapid opening of an investigation as soon as the facts have been brought to the attention of the authorities. Although there is no individual factor that will be determinative, an issue that appears repeated in the case law is the importance of a rapid investigation and judicial proceedings. The Georgia versus Italy, for example, it was the case where the applicant complained to the authorities in 2015 that she had been hit on the head with a motorcycle helmet by her former partner and suffered severe injuries. But despite the serious allegations of violence, the prosecutor failed to conduct a quick investigation. And 7 years later, the proceedings were still pending. And in these circumstances, the court found Italy to have breached its positive obligations to conduct a timely investigation. Why is this that much important? Why this timely investigation is that much important? The mere passage of time may be liable to hinder the effectiveness of the investigation, as the quantity and the quality of the evidence may erode over time. In a climate where we know domestic violence is mainly perpetrated by men against women, failing to quickly and effectively investigate violence against women allows perpetrators to act with impunity. And such situation is not only reprehensible from the perspective of the victim, but I think it also compounds the view that in any given society, women may not afford equal protection of the law. In other words, if you are not investigating domestic violence effectively, it means you're not taking domestic violence seriously. But the flip side of this is also correct, I think. So if you are not taking domestic violence seriously, you are not going to investigate it effectively. Then this brings me to the trial stage. Once an investigation reaches the stage of a criminal trial against an alleged perpetrator of gender-based violence, our court has commented that there are an additional range of obligations that may fall upon authorities. For example, in order to ensure effective participation of the victim in the trial relating to domestic violence, the court has stated in certain circumstances, this procedural obligation may extend to providing free legal representation for victims of gender-based violence. Another important obligation may be to avoid secondary victimization, but I'm not going to get to this because this will be elaborated by my colleague, Kateřina. So from this overview, maybe I can mention like two main takeaways. The first are actually positive obligations that flow from the convention are holistic. And the second, our analysis of the positive obligations are also comprehensive and holistic. So it's not like just tick box analysis. Briefly, just the interaction of these obligations and Article 14, because any presentation on the procedural obligations under 2, 3, and 8 of the Convention in the context of domestic violence, I don't think will be complete without consideration of Article 14. So in some circumstances, the court will hold that the shortcomings in the national authorities' handling of an investigation relating to gender-based violence amounts to a violation of Article 14. I mean, as mentioned by the colleagues, violation of Article 238 in conjunction with Article 14. And this approach was first taken in the seminal case of Opus versus Turkey. Very briefly, what happened in this case? The applicant's husband has been repeatedly abusive towards her and her mother. This has been documented by the authorities. And at one point, there were even proceedings against the husband. These were withdrawn by the applicant. The violence of the applicant's husband, as happens in many cases, escalated and resulted in him murdering her mother. In considering the response of the domestic authorities to the applicant's complaints, the court considered that the law in question at that time, then law changed, was not the problem, but instead the general and widespread discriminatory attitude of the domestic authorities needed remedying. And in line Article 2, classic Article 2 jurisprudence, according to the court, domestic authorities should have known about the risk to the victim's life. Because the victims had made several complaints to the police with serious claims of a risk of danger to their lives, and domestic authorities were aware of the potential risk to life, but they failed to respond. This was significant. I mean, the court considered that, mentioned by our former president, that there was a prima facie evidence that domestic violence affected mainly women and that general discriminatory passivity in the country, for this case it was the most judicial passivity in the country, created a climate that was conducive to domestic violence. This part is important. Creating a climate that was conducive to the domestic violence, because then this was used in other cases, MS versus Italy, in some other cases as well. It was significant, as for the first time, the court recognized the attitudes and approach of the domestic authorities, and the state's response to it can amount to a form of discrimination against women. I appreciate actually nearly 15 years have passed since Opus, and the court's case law has developed since then. Maybe we'll discuss this in the Q&A session. But what happened, what do I mean by the court's case law has developed since then? I'll jump to MS versus Italy, 2020. The court gave fairly comprehensive restatement. So it revisited the approach, so gave kind of a restatement of how it'll now approach claims under Article 14. I mean, very briefly again, what happened? The applicant, upon instigating separation proceedings against her husband, had been violently attacked by him. It took 7 years for the criminal proceedings to conclude against the applicant's former husband, but after the sentence was lodged, the Court of Appeal ruled that it was time barred. MS versus Italy is an interesting one, because the court ultimately concluded that there was no violation of Article 14, despite its holding in a 2017 case, Talpis versus Italy, where the court stated that the state had breached its positive obligations under Article 14. So then what happened, and the conclusion was different in MS, because in MS the court considered that since 2017 and the adoption of Talpis, there were kind of improvements, positive steps as regards tackling gender-based violence in the country. So simply considering the changes made in the country to improve the national authorities' response to domestic violence, the court declined to find a violation of Article 14. Court in its recent case, but very recent one, just one from last month, as mentioned, President O'Leary, AIRE versus Bulgaria, has continued to examine how a state responds to a previous violation of Article 14 in conjunction with Article 2.3. Reached different outcome than MS versus Italy. I'll mention the reasons. Hopefully in the Q&A session, so I don't want to take time. But just one hint, maybe, it was, the court highlighted that this is the third case from the same country, and there was no evidence that the country had developed specific policies to tackle domestic violence. So simply just that there are not enough positive demonstrative attempts to tackle domestic violence. That brings me to the end of my remarks for this part. First, I think the procedural obligations of the state responding gender-based violence cannot be understated. I mean, yes, we know violence against women is not just is perpetrated mostly by individual men, but it is made possible or even facilitated by a failure on the part of the state institutions to adequately respond to violence against women. So I think these obligations actually cannot be understated. Second, on a more personal level, I'm really grateful for this space and platform that allows us to discuss gender-based discrimination, like some other gender-related issues. Because end of the day, I think although we may experience it differently, as mentioned by President O'Leary, no woman is immune from gender-based violence. It doesn't matter who you are, where you're from, if you are single, married, young, old, divorced, but as a woman, you are more likely to be targeted for certain kinds of violence. Because we live in a society, I think, where merely being a woman is challenged for the issues that we're talking today. And until we change this, change society, I struggle to see how gender-based violence will cease to be a problem. Thank you.
Thank you very much, Judge Yüksel. If I can insist a little bit also in view of the discussion we had during the first panel on Article 14. What do you think would be the criteria or the situations where the court would go as well with an Article 14 violation? And I might refer, for example, with the case, might seem as a mea culpa as well, because I was sitting on the case, Robert was presiding the case, Tershana versus Albania, where we found violation of Article 2, a very bold violation of Article 2, but we said not necessary to continue with the Article 14 situation, which is a typical formula approached by the court in Article 14 situations, dealing with Article 14. Now my question is it appropriate for the court, when dealing with gender-based violence, to maintain the same approach in relation to Article 14 and to say not necessary? Is this insistence on Article 14 on gender-based violence necessary always? That is my question.
It'll maintain, but with some improvements. I think that was clear from the first session, and hopefully it'll be also as clear as possible from this session. I mean, I'm not going to comment actually what kind of cases would lead to a violation. So, I mean, you understand as a judge, we may sit in these future cases, but I can mention, or maybe a bit elaborate on the factors that was in my notes actually, but thanks for the question, I didn't mention. So maybe just the factors that may lead violation of 14, again, taking into account the current case law. One factor, maybe, again, stemming from Opus, would be this passivity in the national authorities' attitude. This may be police or prosecutor. What it was in Opus, the passivity was demonstrated by the failure of domestic authorities to launch proceedings. And if I'm not mistaken, in Talpis actually it was kind of similar. The passivity was demonstrated by the fact that the prosecutor had to ask the police in order to take protective measures for the applicant, where the police were already ineffective for 6 months. So I think this passivity of the domestic authorities may be one factor to assess, and I think the court will continue to elaborate on this. But I mean, of course, I don't want to mislead the audience, and I don't want you to leave with the idea that actually the just passivity in an individual case, just passivity of a police or prosecutor is passive, and this will definitely lead us to find a violation 14. I don't think so. I'm not sure actually that evidence from an individual case, the police or public prosecutor were passive, is sufficient to find a violation of 14. Because it seems to me, at least to my reading of case law regarding MS the other cases, I think the court will still require evidence that the failures of the authorities in an individual case is symptomatic of a wider problem. So it's a symptom of a wider problem. So I think it's for these reasons, international reports from a country, domestic abuse statistics, reported cases, how many reported cases result in prosecutions will be also helpful in order to reach an outcome. A violation or no violation, I don't take position, but this will, I think, will be helpful to reach to a certain outcome. So I think it's worth noting that various state does not produce any statistics on domestic violence. This may be used as evidence that they are failing to take it seriously. Second point, hopefully will be helpful to our colleagues at the national level. As I already discussed, the court found violation in Talpis versus Italy, but didn't find a violation in a later case, MS versus Italy. And that, as I mentioned, the reason was that, I mean, the court just stated that the country already took positive demonstrative steps to improve its responses to domestic violence. But in contrast, in AE versus Bulgaria, the court noted that it had not seen any serious attempts by the domestic authorities to improve the situation. So what I'm trying to say is that one factor going forward may be whether a state can show positive demonstrative attempt to tackle domestic violence and change an approach from its previous approach in past cases. Hopefully this answers.
Thank you very much. Now, if I can continue with Judge Wennerström and kick off with a question for you. We heard from Judge Yüksel about the procedural obligations under the convention and the minimum standards which must be implemented in this area. Perhaps it would be useful if you could take us through what, in your view, are the best practices or how these best practices would be applied by the European Convention of Human Rights, also taking into account the work of other organizations, conventions within the Council of Europe and Universal. Thank you.
Thank you very much, and good morning, everybody. Before starting, let me tell you what a pleasure it is to be here. And I would also like to thank the AIRE Centre, the UK government, Biljana Braithwaite and her team for having made this possible, and also my own colleagues who have been very supportive, notably Ivana Jelic, in order to make this possible. A big thanks to you also, Ledi, Bianku, for giving us the good news about the Istanbul Convention. This is really setting the scene for our discussions here in a very positive way. What I would like to use these few minutes in doing is actually a sort of a bridge, a practical bridge between the previous session and this one. This is just as applicable to the operational side as it is to the procedural. And I would like to raise some points on the importance of the continuous development of best practices in both the prevention and the investigation of femicide and gender-based violence, and how this feeds into the standard setting in the case law of the European Court of Human Rights and of national courts as well. Now we've heard the Osman case informing us that authorities must respond immediately to any allegations of domestic abuse and conduct a comprehensive, autonomous and proactive risk assessment in order to determine if there is a real risk to the victims of domestic abuse, in order to be in full compliance with the European Convention for Human Rights. And when a crime has been reported, the investigation must be carried out effectively. Let me briefly refer you to a couple of cases that have already been mentioned from our case law. In Kurt versus Austria, the court stated that the authorities had to provide an immediate response to allegations of domestic violence, and that special diligence was required from them in dealing with such cases. That is not restricted to the preventive phase, so to speak. The court asserted the following, and I quote, "Comprehensiveness in the context of a risk assessment is an element which should characterize any official investigation," and here I echo, any official investigation, "and is equally relevant in domestic violence cases. The court considers that the use of standardized checklists, which indicate specific risk factors and have been developed on the basis of sound criminological research and best practices in domestic violence cases, can contribute to the comprehensiveness of the authorities' risk assessment," unquote. Now, this is interesting in my view. A reference is made here to a standard that is outside the realm of the national legislator, namely checklists, criminological research, and best practices in domestic violence cases. In Kurt versus Austria, the court found that the authorities had displayed the required special vigilance and that there had been no violation of Article 2, but nevertheless set a very important standard in doing so. The case Kateřina versus Albania that was just mentioned, in this case, the court did not find a violation of Article 2 as regards the obligation to take preventive measures of protection, as no information had been provided to the authorities prior to the acid attack. The court did, however, find that the absence of an effective criminal investigation violated the procedural side of Article 2. The court noted that, and I quote, "The circumstances of the assault on the applicant, which resembled a form of gender-based abuse, should have prompted the authorities to act with extra diligence when carrying out investigative measures," unquote. I would say that Kurt versus Austria and Kateřina versus Albania contain some very clear language of guidance, setting out the European standards for gender-sensitive preventive and investigative measures. Now, best practices in investigating all forms of violence against women play a crucial role in developing standards with relevance for all courts. And most states have taken efforts to that are helpful in this sense. I will not go through examples at this stage of the presentation, but apart from what states agencies have provided, you will also find helpful compilations of research, criminological research, police research, protocols, that have been compiled that are also very, very useful. Question is, of course, how do we keep ourselves up to date about best practices and criminological research relevant for the comprehensiveness and standards for investigation that the court's jurisprudence tries to identify? We cannot all become researchers again. Well, you may say it's primarily for the parties to the process to bring forward arguments why this and that best practice and standard has been or has not been complied with. Yes, I agree with you, but naturally, as the masters and carriers of the case law that contains the standard, we must naturally also be cognizant of any such developments. Let me give you 3 examples, or rather resources, that can be helpful if you ever find yourself in that situation. Apart from what is nationally available, let me take an example from, speaking of the Istanbul Convention, GBV, the group of experts on action against violence against women and domestic violence, the monitoring body for the Istanbul Convention. Now, I looked through the baseline reports concerning my own country, Sweden, and our host country, Serbia, just for gaining a few examples and insights. Now, concerning Sweden, in the report, having first identified a number of shortcomings, GBV goes on to strongly encourage the Swedish authorities to ensure that the widest possible use of standardized, evidence-based risk assessment tools by local authorities. In the Serbian baseline report, GBV strongly encouraged the Serbian authorities to ensure that risk assessment is systematically carried out in relation to all forms of violence against women, having first provided a few examples of what it considers not to be in keeping with best practices. The second example I'd like to share with you is the institute AIRE, the European Institute for Gender Equality, which is, as you know, the EU's knowledge center on gender equality, providing expert knowledge, research data, and tools for all those in the EU and candidate and associated countries who need to design or assess measures in society relevant for our conference. Now, what I've come to discover is that AIRE will also provide analysis of national developments, including protocols for investigation of femicide, protocols that are of direct relevance for the emerging best practices in this area in our own part of the world. The third and final example I'd like to share with you is a couple of examples from the United Nations area. The first one being the United Nations Special Rapporteur on Violence Against Women and Girls. This office has been carrying out a number of different investigations that are documented in reports. One concerns the link between custody cases, violence against women, and violence against children. A very interesting and pertinent link. Now, the purpose of this very recent investigation was to inform the Special Rapporteur on Violence Against Women and Girls on this nexus between custody and guardianship cases and violence against women and violence against children, with a focus on the abuse of the concept of parental alienation and other concepts such as this. This report is in the process of being finalized if it hasn't already been published. The second UN report I'd like to mention comes from a source where you would not perhaps start your inquiry, namely the UN Special Rapporteur on extrajudicial summary or arbitrary executions. Now, this office is currently carrying out an investigation and documentation of gender-based killings of women and girls. Deadline for input was 19th of May, so this is in the making, and we won't be seeing this for months to come. But I should let you know that the purpose of this investigation is to collect information on laws, policies, standard operating procedures, and practices for investigating and documenting the gender-based killings of women and girls that might be characterized as femicide. Now, this is of direct relevance for our work, I would say. So this is one to keep an eye out for. Two relevant documents to keep a lookout for. Ladies and gentlemen, these are but 3 examples of knowledge sources developing that should be relevant for any practitioner in this field, including ourselves, as we rely on observing best practices and comparing behavior that is before us with such best practices. I think we need to continuously keep ourselves updated about these developments, and I'd be happy to answer any questions on that. Thank you.
Thank you, Judge Wennerström. Indeed, you kind of replied to the second question I had prepared for you, but your presentation makes me adapt it a little bit. And this is also a question for you, question for Biljana and her team as well. We're all speaking about best practices. And my question is, how do Swedish judges identify best practices? And whether it would be a viable project for AIRE Centre to have a platform on the website of the AIRE Centre Gender Forum with a catalogue of best practices, which might be updated, case law of the court, the reports from Grevio, other international organizations. Do you think this would be something helpful for judges in Sweden or judges from the region?
Thank you very much. Yes, I think any effort to combat the problem that we are facing requires a multitude of different measures. We have touched upon the legislative side. Now, this is important also for what is possible to try to combat, to make sure that the procedural burden of, for instance, maintaining a charge against an alleged criminal is not on the is rather on the state rather than on the victim itself. But you have other measures that are more in the line of training, I would say, sensitizing the officials that are carrying out the investigations in order to make them aware of what is likely to contribute to a re-victimization of a victim in the course of the judicial process. This is not necessarily possible to target with legislation, but it's rather a continuous process of training, I would say. Now, you asked about the Swedish example, and this is where I find a toolbox of at least 3 government institutions and a number of universities that are all contributing with knowledge on best practices to the Swedish agencies that are at local and national level that are carrying out this work. Now, a few of these bodies have the power to force the hand of the investigation, if you will, or the procedure. But they can definitely contribute to the level of knowledge and sensitivity of those carrying out these procedures.
Thank you very much, Judge Wennerström. And if I can move to Judge Šimáčková for a question. We've heard some examples from the way the court applies the positive obligations and also on the best practices. Which are, to your opinion, some of the procedural difficulties, obstacles that state authorities mostly find in pursuing these standards and the positive obligation investigation of gender-based violence? Thank you.
Thank you very much, dear colleagues. Thank you for the opportunity to share with you my experience and thoughts about gender-based violence. And I very thank for the great conference we can participate in, especially all excellent women from AIRE Centre and also Ivana Jelic. So sorry for this repetition. I have chosen a rather specific, a rather new but emerging topic, namely the statute of limitations and passage of time for cases of domestic violence and good investigation. Both this statute of limitation, both in criminal proceedings against the perpetrator and in civil proceedings in which the victim seeks compensation and invokes the responsibility and the liability of the state or public power, of public authorities. The question of the proper assessment of the statute of time limitations can relate to many cases of sexual violence. This is because victims often come to report rape or similar sexual offenses only after a long time has elapsed. So it's not the problem of femicide because it's really visible, the victim, but other sexual offenses. I would like to refer to this topic in the context of the case of our court of Loste against France, and also recall one new communicated case from the Czech Republic. Our fifth section, led by President AIRE, dealt last year with the proper determination of the statute of limitations and its beginning. It was very important, the beginning of the period. In this case, Loste against France. It was a very sad story. A little Muslim girl was placed in the foster care of a family professing Jehovah's Witnesses who practiced proselytism towards the child. Even when it was discovered that the foster parents refused to agree to a blood transfusion for the child, the French authority looking after the children left the child in the care of the foster parents, even though they had promised to maintain religious neutrality and also to the confession of the girl. She was Muslim girl. This authority did not even address the fact that at some point the child became very nervous and had difficulties at school. It was subsequently established and clearly proven, including a partial confession of the abuser, that it was in that situation that the foster father had sexually abused the child in a very young period of her life. Our applicant was then in an extremely closed environment under the indoctrination of a very specific religion, so it was very difficult for her to detect the abuse of the foster carer, and so it took a long time. She did not bring a claim until between 2001 and 2004, but the sexual abuse took place before 1983. Both the criminal proceedings against the abuser and the civil actions were dismissed due to the statute of limitations. In the course of the proceedings, I told it, the abuser admitted in part that he had committed sexual violence when the applicant was a child. In a first judgment of December 28, 2006, the first instance administrative court, French administrative court, ordered the state to pay the applicant the sum of 22,000 euro as compensation for the damages she had suffered as a result of the sexual abuse and the failure to respect the neutrality clause with regard to the religion opinions of her family of origin, which had been made possible by the failure of the State Department responsible for child welfare. I will quote only one sentence from that judgment. These assaults were made possible until 1983 by the failure of the state, which was responsible for child welfare, to exercise the control it was required to exercise over the conditions of the applicant's placement in this family. The state is therefore liable for the damages suffered by perpetrator as a result of the said sexual abuse during that period. But in the end, however, the action for damages against the state or region, because it was also debate, it's the state or region responsible, was also dismissed because of the statute of limitations. The European Court of Human Rights found unanimously violation of Article 13, so effective remedy, in conjunction with Article 3 and 9, and also pure violation of Article 3 and 9 of the Convention, and ordered the state to pay the applicant 55,000 euros in damages. I speak also about the sum to show really the very specific and very hard situation. According to established case law on the right of access to a court guaranteed by Article 6 of the Convention, statutory limitation periods are among the legitimate restrictions on this right and serve several important purposes. It's necessary to underline. To ensure legal certainty by setting a time limit on actions, to protect potential defendants from late claims that may be difficult to counter, and to prevent the injustice that could occur if the courts were called upon to rule on events that occurred far in the past on the basis of evidence that could no longer be relied upon, and that was incomplete because of the passage of time. However, as regards the balance to be struck in the context of statute of limitations between, on the one hand, the right to an effective remedy, and on the other, the defendant's right to legal certainty, the court has repeatedly emphasized that in applying the relevant procedural rules, domestic courts must avoid both excessive formalism but also excessive flexibility. But this excessive formalism would undermine procedural fairness. In that case, the court considered that the national courts applied a procedural requirement in such a way as to impede the examination of the merits of the applicant's case. The interpretation and application of such a requirement, while legitimate in principle, may in certain circumstances be such as to entail a violation of the right to effective protection by the court. The national courts ruling between 2010 and 2012 with all the information relating to the criminal and administrative proceedings initiated by the applicant at their disposal, could then have taken these factual elements into consideration in concluding that it was only as from February 24, 1999, that the applicant became aware of the documents in her file revealing the alleged failure of the national authorities to act, and that she then had sufficient indications enabling her to show that her damages was attributable to the administration's actions and to bring her action for compensation. So it's very important, the beginning of the delay. The national courts therefore correctly failed to determine the date from which the applicant had sufficient evidence to demonstrate the liability of the state. The court concluded, in the very particular circumstances of the case, that the domestic courts displayed excessive formalism, the effects of which are incompatible with the requirement of an effective remedy. But we found also really the meritorious violation because of completely, that really the Child Welfare Service failed to protect the applicant from sexual abuse within the foster family with which she was placed by the state when she was a minor. Next, let me introduce the case that have not yet been decided, but have already been communicated, so you can find it also in HIODAC. So it was communicated to the Czech government. It's two cases. There are two applicants who state that in their early youth, they were victims of sexual assault by Catholic priests. Also, the closed environment with a long period to decide for really disclose this shame for the victim. The first case concerned the fact that the sexual assault was identified as sexual coercion and not as rape. It was precisely in view of this qualification that the perpetrator was not prosecuted. Sexual coercion was not criminally punishable at the time it was committed, the behavior, the act. It only became part of the criminal code after the offender committed it. The applicant argues that the conduct against her had the elements of a more serious offense, which was already punishable at the time of its commission. The time aspect also plays a role, as well as the fact that only the prosecutor dealt with the case, not the courts. However, the second case is more important for the legal problem of status of limitation. In that case, why against the Czech Republic, the police considered that perpetrators' actions did not constitute rape because the low level of resistance put up by the applicant. She was unable, she was also minor, and she was up to them, unable, owing to her character traits and emotional instability, to express her disagreement either verbally or physically. So not minor, she was 17 at that time, so up to Czech legislation, it's not fully mature. According to the police, the applicant preferred to be subjected to sexual abuse by perpetrator in order not to deprive her family of perpetrator's material and financial support. The public prosecutor disagreed with the finding of the police investigation, and the perpetrator, we use the abbreviation PJ, had in this case abused the applicant's dependence and his own position, credibility, or influence within the meaning of Article 186 of the Czech Criminal Code, defining sexual coercion. The public prosecutor concluded, however, that there was no reason to refer the case to the District Public Prosecutor's Office and to the court, since the 5-year limitation period for the offense of sexual coercion had expired. The applicant invoked before our court the state obligation under Article 3 and 8 of the Convention to punish non-consensual sexual acts and to investigate sexual offenses effectively, arguing in particular that PJ's action should have been classified as rape, and that the 15-year limitation period should be applied in this case to the offense of sexual coercion because of the serious damages to her health. So the case was open for this more complicated sexual coercion and for rape, but prosecutor decided not to go before the court because it was normal sexual coercion and it's the long time. Communication of the court was based on the question if the state fulfilled its positive obligation inherent in Article 3 and 8 of the Convention to adopt and effectively implement criminal law provisions, including status of limitation, to criminalize and punish all non-consensual sexual acts, including cases in which the victim does not physically resist. In concluding that PJ's action did not constitute an offense of rape, were the authorities careful to avoid rigid and restrictive interpretation of the elements of sexual offenses, namely that there could be no rape without the use or a threat or force and without the victim continuous and genuine resistance? Was the authorities' application of the rules on the limitation period for the offense of sexual coercion compatible with their obligation under Article 3 and 8 of the Convention? Unfortunately, in that case, I only have this question for you, not answers yet. This case is still pending, and we don't know how it will be decided. But according to the case law regarding the Czech Republic and also these two cases, we can see that cases of not only sexual attacks, but also of police violence is based on that the police or prosecutor may decide not to prosecute even against the will of the victim. Maybe it would be better to involve also courts in the decision to stop or not investigation in such serious and complicated offenses. Thus, all decisions of the prosecutor's office to discontinue prosecution in such serious cases must be submitted directly to the Constitutional Court without judicial review before the ordinary courts. So the perpetrator has 4 court instances in our country to defend himself, but the victim of rape, of murder, of police violence can find help exclusively before the Constitutional Court, for which he needs good legal representation and a clear evidentiary situation. Thank you.
We have little time at our disposal, but however, I'm tempted to ask a question. You can reply because you are a sitting judge. I know your situation, or not. My question is, to what extent the EU accession to the Istanbul Convention would change the legal setting in the Czech Republic, considering that Czech Republic is one of 2 or 3 EU member states not having ratified the Istanbul Convention. Of course, Istanbul Convention for EU is applicable on the EU matters of competence, but still is applicable, for example, judicial cooperation in criminal matters, asylum, migration. So do you think this would have an impact in these areas?
So thank you very much for that question. Really, it's not my role to interpret EU law and obligation in the international law for member states. But if you started to speak about the Istanbul Convention and EU, I started to be ashamed because I'm from that country. And it's true that I was editor a book about gender equality and criticism of the gender criticism of our legal regulation. And we had 3 articles about the Istanbul Convention. And we asked why the situation in my country, it's so complicated in order to vote for Istanbul Convention, because I think that the situation of victims on the legal basis, it's maybe better than in other Central or Eastern European country. We changed since 2004, we had changed criminal code, police law, also procedural law. We have new offenses against abusers. We have possibility of police and of civil courts to stop a violent person and to protect the house or apartment before him. Also, if he is owner of that house. So one argument in our environment is we don't need Istanbul Convention because we prepared everything that is necessary. It's not true, because I think we have some problems in the area of prevention. For example, this possibility to call, to find asylum for women with children, etc. So it's up to me. It's not done everything, but it's one of the most commented arguments. But I want also to say that I see the similar argument, why not to go to Article 14 if we have Article 3 or Article 8? So why speak about discrimination if we make the good steps in merit? So we have a big debate that it's this so-called new gender ideology that can be dangerous. It's dangerous to teach children at school about this against gender stereotypes, because we can change the role of the family, etc., etc. So I think it's a little bit the position. We don't need it, one position. And the second is it's a little bit dangerous to speak about gender stereotypes and to finish with that, because it's our tradition to have different roles for men and for women. So I think it's the problem. And in April, because the topic of your session is also femicide, and it's true that during that April, it was 3 femicides committed in Czech Republic, and it was visible that all these 3 cases, and it was a murder of twice women and woman and child. Woman was really very in very bad health conditions, but the child and parents of the woman were killed. So, and it was really signs that it's long period. It's up after long period of domestic violence. All these 3 cases, and maybe it can show our society that it's important to speak about the problem, and maybe there are some problematic stereotypes in our society, and only because also Saadet spoke about it. For example, we have some problems with secondary victimization of victims. So in criminal proceeding, we have special rule. It's necessary to protect the victim, but it is not applicable in civil proceeding. And after the end of domestic violence, you need to be divorced and other steps in civil proceeding.
Thank you very much, Judge Šimáčková. I see raising hands. Please introduce yourself, President.
Thank you. I'm the President of Constitutional Court of Albania. I'll be brief. Thank you very much for your presentation, very comprehensive, provided a lot of food for thoughts, actually. I would like to raise, or to draw attention actually, on a very specific matter regarding procedural instruments and their importance on how they can affect the outcome of a criminal proceeding. We had recently a case in our constitutional court regarding a femicide, happened 15 years ago. So the procedure, the length of the procedure was almost 15 years. Based on that, we checked, we were all the judges, we have 6 female judges, so everybody was very sensitive on the case. And then you see how the law provides protection for the victims within procedures, and then you see a lot of limitation, which is also something normal in criminal proceedings in general. So basically, the victim has a standing only for certain procedures, which is only the dismissal of a criminal offense by the prosecutor, or if the whole proceeding is dismissed by the court. Other than that, there is no standing of a lawyer for the victims to be part of the proceedings, to be able to debate on evidence, on their admissibility, or even to ask for new evidence. And having this limitation will greatly impact the outcome of the criminal offense. So the case we had in front of us was regarding the evidence that were provided and were admitted in the court. So we didn't find standing for the father that was trying to present a case on behalf of the daughter that was killed by the fiancé. And with that scenario in mind, I totally agree with the proposal here from the Judge Wennerström regarding having investigational protocols for femicide, for gender-based killings. This should come, I know that the instruments of Council of Europe and of the courts are somehow, I mean, you can see it, and it's just a suggestion and recommendations probably for AIRE Centre to see it on that perspective. To see the possibility of having a mandatory instrument, or at least a guiding instrument. I mean, there are others. But at least this will provide a basis for these kind of criminal offenses to have a special attention. And if we think about protocols, at least the courts will be able to verify, to have another sets of principles and norms how to verify the work done by the prosecutor. We know that the general rule is that the prosecutor is the attorney of the victim, but we know that especially because of the peculiarity of this kind of criminal offense that we all, I think, admitted that has already how to say, it can amount to discrimination because we assumed and we accepted that because most of the time prosecutors are men and maybe they don't have the same sensibility toward this kind of criminal offenses. You need to have special rules. I'm not able to tell you which one, at what level, but some types of standard that will guide the courts and will enable and will provide a better defense mechanism for the victims within the procedures. I urge you to see that, and hopefully maybe in the next forum we'll see some results in that regard. Thank you.
Thank you very much, President Zacaj. Ioannis, please, very briefly.
Just if you allowed me just to add it, I think that if there is no a precise criminal offense, we cannot apply reliable protocols, which can be also used at the later stage by the European Court of Human Rights. It's the criminal proceedings which is the starting point for the protocols. This is my reaction, just to add it to your intervention.
Very brief. Dobar dan svima, ja sam Biljana Sinanović, sudija Vrhovnog suda u Srbiji i pre svega izražavam zadovoljstvo što je ovaj skup organizovan u našem gradu. Želim vam svima koji ste ovde prisutni da vam ovde kod nas bude lepo i da nam dođete opet. Drago mi je što govorimo o primjeni konvencije i to je nešto o čemu možemo stalno da razgovaramo i ono na što želim samo da skrenem pažnju kao sudija krivičar, rekavši vam prethodno da Srbija ima, čini mi se, dobar zakonodavni okvir, imamo krivično delo nasilja u porodici, dobar raspon kazni, imamo zakon o sprečavanju nasilja u porodici, imamo zaštitu za žrtve kroz porodični zakon, kroz zakon o zabrani diskriminacije. Nažalost, imamo i jako teška krivična dela i imamo nesmanjen broj teških krivičnih dela u odnosu na žene i u odnosu na porodično nasilje. Iako postoji zakon o porodičnom nasilju, ima veliki broj krivičnih dela, ali nažalost taj broj se vremenom ne smanjuje. Kao što znate, u poslednje vreme smo se suočili sa ogromnom tragedijom, sa dve tragedije za koje nemamo odgovora i ne znamo šta nam se to desilo. Međutim, ono na što želim kao sudija da vam skrenem pažnju, to je da se žrtve u sudnici i kod tužioca nalaze u situaciji da razgovaraju sa tužiocem, odnosno sa sudijom. Jako je važan odnos koji žrtva, koji sudija ima, koji tužilac ima prema žrtvi. I jako je važno ono pitanje kulturološke dimenzije koje se već pomenulo, odnosno predrasuda i načina razmišljanja kod ljudi koji razgovaraju sa žrtvama. I to je nešto o čemu mi moramo da vodimo računa i što mislim da moramo, evo i kroz ovu mrežu koju ste osnovali, i kroz naš rad sa mlađim sudijama, mlađim tužiocima da radimo. Jer žrtve se neće odvažiti da se ponovo jave i neće se odvažiti da prenesu svoja pozitivna iskustva ostalim žrtvama da prijave krivična dela. Pritom mislim ne samo na žrtve koje su neposredno oštećene izvršenjem krivičnog dela, već i na one koji nisu neposredno oštećeni, odnosno koji su srodnici žrtava koje su, recimo, lišene života. Sudije moraju biti dodatno obučene o tome da znaju kroz kakvo mentalno stanje prolaze žrtve kada se nalaze u sudnici. Nažalost, mi imamo veliki broj i mladih sudija koji to i zbog svog iskustva profesionalnog i zbog svoje mladosti prosto ne uzimaju u obzir. A mislim da je to pitanje veoma važno, nezavisno od smernica i protokola koje imamo, ali zavisno od prava okrivljenog, koja se takođe moraju poštovati i kada se mora dovesti u ravnotežu pravo žrtve i pravo okrivljenog, onda se u svakom slučaju žrtva ne sme ostaviti sa utiskom da joj se ne veruje. I mislim da je to jedno jako važno pitanje i na tome je potrebno dosta raditi, jer to znanje vam donosi iskustvo, a sudije nisu uvek iskusne. Hvala vam.
Thank you very much for your interventions. I close the panel by thanking the three members of this panel, three judges, for their valuable contributions, and I thank you all for the attention and the participation.